So what has the court actually ruled in terms of the right to privacy? Well, as I've mentioned a couple times, what I'm about to talk about is particularly relevant today, or it will be in a month, when the court finally rules on whether or not Roe versus Wade, this court case that I'm going to talk about, is constitutional. So before I explain what the courts have done in terms of the right to privacy, let me give you some background. Typically, the courts are very suspicious of any attempts on the part of the government to limit people's liberties, right? So when the government passes a law that limits people's freedoms, the courts generally require the government to demonstrate that it has a compelling interest, which is a legalese for saying a really important reason why people's rights should be limited. And they'll allow it if the government can demonstrate they have a compelling interest to do so. For example, we have freedom of speech, right? And the courts defend freedom of speech all the time. They push back on efforts on the part of the government to limit freedom of speech. But can you go and yell fire in a crowded theater just for fun? I mean, if it's on fire, you might do it. It might not be a good idea to just yell it. You might want to say, hey, the theater's on fire, pass it down. But leaving that aside, can someone just run in and say, fire? People start stampeding and running over and injuring one another, and then they say, hey, I have freedom of speech. If somebody would be arrested for doing that, and they might go to court and say that law limited my freedom of speech, and the courts would say, you know what? No, you're going to jail. The government has a compelling interest in limiting freedom of speech in cases like this because it's a threat to public safety. So they will allow limits on our liberties and our freedoms, but the government has to demonstrate that there's a compelling reason to do that. Well, in 1965, there was a court case, a very famous court case called Griswold versus Connecticut. And what the case was about is many, many years earlier, the state of Connecticut had passed a law that had made it illegal to sell contraceptives in the state of Connecticut. And so somebody purposely sold contraceptives in Connecticut because they wanted to challenge this case. They wanted to challenge this law. And so the person, I think it was a gynecologist, I forgot who did it. I think it was a gynecologist had sold the pill to somebody, or maybe it was a pharmacist had sold the pill to somebody, but they did it in a way that it was like clear what they were doing. They were arrested for violating this law that banned the use of contraceptives, and they took it to court, and their argument was, this law violates my right to privacy. And the courts overturned the law. They said, you're right. The law is gone. And they made the argument that I made before. They said there are provisions in the Constitution that imply a right to what they called marital privacy, since we know that only married people have sex. The court said there's an implied right to privacy that this law violates, and that the state did not demonstrate that it had a compelling interest in limiting this right to privacy. And so this law was struck down, and the courts in 1965 declared for the first time there is a right to privacy in these kinds of matters, private marital matters. Well, in 1973, the very famous case, Roe versus Wade, is settled and brought before court. In this case, it's somebody who was seeking an abortion when abortions were made illegal by state law. Everybody thinks that Roe versus Wade was about abortion. That was the topic. But if you read the court's rulings, the court ruled that the laws prohibiting access to abortions were a violation of the right to privacy. Roe versus Wade was a decision about the right to privacy, and what they ruled in that case was states do not have a compelling interest in limiting the right to privacy during the first trimester of a pregnancy. The basic argument was that during the first trimester of a pregnancy, the first 3 months, it's a relatively safe operation. There's no need for the government to get involved, just like they don't regulate all kinds of operations that aren't a danger to anybody. And so they said in the first trimester, there's no compelling reason why the government should interfere with what is a private decision, something that falls within the right to privacy. But they said during the second, states may have a compelling interest in limiting the right to privacy during the second trimester, because by the time a woman is that far along in her pregnancy, it is a more dangerous operation, and so they can place limitations to protect the life and the health of the mother. That doesn't mean just banning it. They may require that only certain hospitals can do the procedure, that there has to be some sort of notification of the dangers involved. They can place whatever limits for the reason of protecting the life and health of the mother during the second trimester, the months 4, 5, and 6. And they said during the third trimester, states may also have a compelling interest in limiting the right to privacy to protect the health and life of the fetus, the unborn child, the baby, whatever you want to call that. We all know what I'm talking about. And they said in particular, once a fetus is viable, the state has a compelling interest and may have a compelling interest in protecting the life of the unborn child. Viable, the word viability just means that the baby is sufficiently developed that it could live outside of the mother's body. That's what Roe v. Wade really was. And really, as of May 20th, 2020, that's what Roe v. Wade was all about. It was a question about a right to privacy. What's really fascinating about this case, and it'll be resolved in a month from now, but depending on when you're watching this video, this could be a history lesson, is that typically the people who are in favor of overturning Roe v. Wade are conservatives. But conservatives are also usually the ones who are worried about government interference in people's private lives. But on the issue of abortion, because for many it's a religious thing, they believe that in a case like this, because of how they view the unborn fetus, they believe that the government has a compelling interest, and they would argue an obligation to protect the fetus. Liberals typically are the ones who are in favor of government intervention to make a more perfect union. But their argument is that in these kind of decisions, the government doesn't have a right to get involved. That this is a decision that a woman should be able to make with her doctor and on her own. And if it's a religious thing between her and her who she believes her creator is, if she believes in a creator, it's up to the woman to make the decision because it's her body. And so liberals who typically are in favor of government involvement are saying hands off on this. So it's going to make for an interesting case, and depending on when you are viewing this, you'll know more about, you certainly know more about the outcome than I'm going to know that I know today. And we'll see what happens in the future. Okay, there's one more video after this, but none of what I'm going to say in the next video is going to be on the exam. So if you want to skip it, go ahead. But it's interesting, I think. You tell me.